Delighted to welcome you to the first of our webinar series on NEC contracts. This series of 3 webinars will start with today's introduction to NEC contracts, looking at the background, principles, structure and common issues. And in the next webinar we will focus more closely on the introduction of the new NEC 4 contract, looking at the changes that have been made to NEC 3, and then in the final webinar of the series of 3 we will provide an update on recent case law relevant to NEC, and we will discuss the lessons that can be learned from those cases. Now before we begin, there's a few housekeeping issues to address. Firstly, to minimise background noise, we've placed you all on mute. If you would like to ask any questions, then please do so using the webinar chat function. In order to keep within the 30 minutes, we will answer as many questions as we can at the end of the presentation, rather than as we go along. So I am Ian Drummond, a partner in the Construction and Special Projects team in Shepherd and Wedderburn, specialising in construction and engineering dispute resolution, and I'm based in Edinburgh. And I'm joined today by Lee Hurd, a solicitor in my team. Our team regularly advises on transactional issues and dispute resolution matters in construction across a wide range of projects and clients, including private and public sector clients and contractors, consultants and funders. So we therefore have extensive experience in helping clients to work with construction and engineering contracts, including NEC, and we have a solid grasp of recent developments in the judicial approach to these contracts. This forms the basis of the advice that we give to clients and of the information we will share with you today. I'll now pass you on to Lee, who will run through the agenda for today's webinar.
Thank you, Ian. As Ian has noted, today we are providing an introduction to the NEC contract and principles. We will start by giving a brief background and history to NEC contracts, particularly considering the philosophy and objectives of the standard form drafters. We will then consider the structure, layout and terminology of the conditions and how this differs from other standard form contracts. The last section of our webinar will then focus on identifying some of the standard form gaps and pitfalls to be aware of when using NEC. No doubt some of you may be familiar with NEC contracts, but hopefully this initial webinar will be a useful reminder of the general principles and approach which we can expand on in the next 2 webinars, together with the changes contained in NEC 4. Hopefully by both reviewing the background and basics of these contracts and then looking at the ways in which they can be made more robust and usable, will provide something for everyone listening to this webinar. So let's start at the beginning and remind ourselves how the NEC contract came about. The construction industry in the UK was historically very adversarial, with lots of disputes and also a lot of litigation, often at the end of projects. Employers were often accused of withholding payments against contractors, and this was having a serious impact on contractor cash flow. In the 1990s, concerned with the level of general dissatisfaction with construction projects and the construction industry more generally, the UK government commissioned a number of reports trying to establish what the key industry problems were and how the construction industry's performance could be improved. The reports, namely the Latham Report, Constructing the Team in 1994, and the Egan Report, Rethinking Construction in 1998, helped to establish a shift in attitude within the construction industry towards less adversarial and more collaborative working models. Principles such as clear design responsibilities, using coordinated project information, avoiding pay when paid provisions, having clear allocation of risks, and speedy dispute resolution in order to minimise the actual impact of disputes on the project, were all considered and advocated by both Latham and Egan. In parallel, and as a consequence of this shift in attitudes, the Institution of Civil Engineers, who had long published civil engineering works contracts, published the first new engineering contracts in 1993, and the suite of contracts has been known ever since as the New Engineering Contracts, or NEC. The third edition, known as NEC 3, was introduced in 2005, following which updates to that edition were released in 2006 and 2013. The most recent edition of the NEC contracts is NEC 4, which was made available in June of this year. Since NEC 4 was only introduced a few months ago, NEC 3 is still very much in use in the construction industry at the moment, which is why it is important to have a good grasp on both suites of documents.
It's probably fair to say that alternative standard forms of contracts such as JCT or FIDIC still largely reflect a traditional adversarial approach, and these would be difficult to amend to substantially shift that focus. Even those with partnering options are not able to match the collaborative approach of NEC contracts, and in some respects that's probably why the ICE decided to draft NEC contracts from a blank sheet of paper, so that their aspiration of a new, modern and collaborative approach could be built into the contract and weaved throughout, rather than just being bolted on or amended. The NEC contracts have been promoted since their inception as an example of best practice and collaborative working, and have been modelled and evolved to match the changes in working practice within the construction industry since the 1990s. These NEC contracts have been increasingly adopted on large-scale construction projects, particularly public sector-led projects, with high-profile examples including the London Olympics project and Crossrail. And they've also been used in international projects as the drafters intended.
So, what is best practice and what are the objectives and philosophy of NEC contracts? It may be somewhat unusual to discuss the philosophy of a legal document or contract, but it is helpful with NEC contracts to consider their underlying philosophy, as it does underpin the objectives and drafting of those contracts, and also therefore their use and interpretation. As we've already mentioned, NEC contracts promote best practice and collaborative working, which is encapsulated in the overarching requirement to act in a spirit of mutual trust and cooperation, which mirrors the first key principle advocated in Latham's report. Whilst this provision can be criticised by some as an unenforceable statement of aspiration only, it does signal a contrast to the traditional adversarial approach to contracting in the UK. It is intended to be a contract which helps you to actually manage the project as you go along, and not a contract that is signed and then left in a drawer just to be looked at in the event of a problem, dispute or claim. Our experience is that when the contract is operated properly, many of its aims are fulfilled, but then the opposite is also true.
Idealistically, the objective of the NEC drafters was to prepare a simple and direct standard form contract with a high degree of clarity and flexibility, which could be a stimulus for good project management. In practice, this can prove its downfall because the standard and level of project management required of both sides in the project is often not achieved, and the contract is difficult to apply in those circumstances. Simple language in the present tense is used and legal jargon is avoided, and terms that we are probably all familiar with, such as force majeure and latent defects, are avoided. Wherever possible, identical phrases are used and repeated in the drafting. But the downside to this approach is that some of the standard terms which the drafters have avoided have a history of case law behind them to provide certainty and meaning. And the simple language used in the present tense throughout the drafting can create uncertainty when trying to apply it to real situations. The contract focuses on planning and programming and identifying risks as early as possible rather than leaving claims to the end. The early warning procedure for notifying causes of delay or additional costs at an early stage and meeting to resolve these, called risk reduction meetings, is designed to provide all parties with the best opportunities to mitigate and resolve the delays and costs in a collaborative manner and contemporaneously with the event, rather than just allocating the risk and letting events play out with claims to follow. Similarly, the risk register and program are intended to be constantly evolving and to be updated to help actively manage events and their consequences. One of the main points to note is the additional project management and administrative resource required on both sides to not only manage the project but also to manage the contract. Because NEC philosophy is that good contract management is intrinsically linked and essential to good project management. So without this resource being allocated and the contract actually being used in this way, then many of the benefits of the contract will not be realised.
We will now take a brief look at the structure, layout and terminology of NEC contracts before we look in more detail at their gaps and pitfalls. Firstly, we should mention that the NEC contracts are actually a suite of contracts which cover professional services appointments, frameworks, engineering contracts and subcontracts, service contracts, and the new NEC 4 edition also now includes a design, build and operate contract, as well as a new alliance contract. We are presently focusing on the contracts between the employer and main contractor, known as the engineering and construction contract. As those familiar with NEC will know, the contract is made up of core clauses and then main, secondary and additional option clauses, with the cost component and contract data at the end. The core clauses cover the main terms and conditions and are the same across all of the contracts regardless of the primary and secondary options selected. The core clauses set out the main responsibilities of the contractor, time elements such as programme and completion, testing and defects, payments, compensation events, which are the events that would entitle the contractor to more time or money or both, which are known as variations in other contracts, risks and insurance, and also termination provisions.
The main option clauses then provide options A through to F relating to pricing. Option A is a priced contract with an activity schedule where the contractor prepares a list of activities to be carried out in the works and supplies a price for carrying out those activities. Option B is a priced contract with a bill of quantities. So the employer would prepare a list of items and quantities in the usual way, and the contractor would price those. The contractor is then paid following the actual measurement of the quantities of those items carried out. Now in contrast, options C and D are target contracts with either an activity schedule or a bill of quantities, and these are effectively a cost-plus contract, with the intention being that the employer and contractor share the financial risk through pain or gain. Option E is a cost-reimbursable contract, where the contractor is paid for carrying out the work plus a fee uplift. And finally, option F is a management contract, where the contractor is responsible for managing the design and individual work packages and subcontracts out the construction work. The contractor will be paid a fee as well as the cost of the subcontract packages. The main option clauses also provide for a dispute resolution route, and these are known as W clauses. There are different W clause options depending on whether or not the project falls under the Housing Grants Construction and Regeneration Act 1996 in respect of the adjudication provisions. But whether the project does or does not fall under that Act, under the W options, the dispute can be referred from adjudication onward to a tribunal, being arbitration or court. Now, NEC 4 also introduces a third option for projects not covered by the 1996 Act, which allows the dispute to be referred to a dispute avoidance board. We'll discuss this new dispute process in more detail in one of our later webinars.
The secondary option clauses are known as X clauses, and it is then up to the parties to decide which clauses apply and don't apply to their circumstances. There are a number of standard form X clauses to choose from, covering issues such as inflation, change in law, parent company guarantees, performance bonds, and retention. There are also a number of UK-specific clauses, known as Y clauses, which cover the payment mechanisms for construction contracts governed by the Housing Grants Act, and also third-party rights. So, up to this point, the contract is formed by picking the parts of the standard form drafting that you consider is required for your project, with this selection being clearly recorded within the contract data section. This approach is intended to provide for a shorter and more flexible standard form contract, which can be applied to different contracts without substantial amendments. Moving on to additional clauses. Additional clauses are known as Z clauses and are used to amend the contract where parties want to, for example, with respect to design responsibility or compensation events. There are no standard form drafted Z clauses, but it's usual for legal firms, developers, contractors, or employers who regularly use NEC contracts to have built up a bank of their own standard Z clauses that can be proposed and deployed as appropriate to that project. We have seen these Z clauses range from reasonable required amendments to reflect specific circumstances of a project or to fill in blanks, to wholesale amendments that really change the philosophy of the underlying NEC contract. Finally, the contract concludes with the contract data itself, which is really the project-specific data, such as the parties, the works description, and the specifics of the main, secondary, and additional clauses selected. This contract data section is the main section which has to be filled in and completed by the parties. Although all of this has been a bit of a whistle-stop tour of NEC, hopefully if you do pick up now an NEC 3 or NEC 4 contract, whilst it won't look like other standard form contracts, it now shouldn't be wholly unfamiliar to those of you who haven't come across it before.
Now, the NEC contracts, like most standard form contracts, were not designed to be amended, and drafters would prefer them to be used unamended. However, as Lee has said, it's fairly normal now to see the whole suite of contracts being amended using a formal schedule of amendment drafted as the Z clauses. These amendments may seek to alter the balance of risk under the standard form, but sometimes they are also designed to bring clarity where the standard form hasn't achieved this. So, we'll now have a look at some of the common gaps and pitfalls of the standard form NEC contract, because these are the areas that we would be advising clients about and where we usually see proposals for amendments as the contracts are negotiated. We don't particularly see these amendments as being either developer or contractor friendly or altering the spirit or balance of risk of the NEC contracts, but rather as areas that all parties will likely want to see improved. NEC 4 has aimed to address some of the widely acknowledged pitfalls of NEC 3, which we will come on to discuss. However, we are not yet able to assess how these amendments will work in practice in the marketplace. The first gap is in the definitions within the NEC contracts. These contracts have two types of defined terms. Firstly, those that are defined in the contract data section, where the terms are usually written in italics. And secondly, those that are defined within the core clauses section, usually written with an initial capital letter. NEC contracts, however, do not have an exhaustive list of definitions. Many usual and obvious definitions are missing, and it's normal to add these. So one example would be the definition of applicable law. Whilst the NEC 3 contract does note varying obligations on the parties with regard to applicable law, it doesn't define what this actually is, and therefore the extent of obligations linked to applicable law are uncertain. So adding a definition of this term fills this gap and eliminates a needless uncertainty for all parties. There are other similar examples. A particular pitfall to be aware of is the importance of completing the contract data section, because this information often doubles as the definition referred to in the conditions. So, for example, all reference to the works in italics leads back to the empty box for that term in the contract data, and therefore any failure to complete that with an adequate definition, or worse, leaving it empty, would result in a large hole across the contract. So the importance of both parties completing their sections of the contract data accurately and in full cannot be stressed enough. Also, because the contract structure provides for all descriptions of the scope and specification of the works to be contained in external technical documents, unlike other standard forms, it's critical that those documents are listed in the contract data and they are accurate. This applies equally to the contractor's design documents.
Given the significant focus on programming and project management in the NEC contract, it is surprising that the conditions in NEC 3 do not provide for what is to happen when the project manager rejects a contractor's program, or if the project manager simply does not respond when receiving such a program. Thus, in practice, projects often proceed with no accepted program. A contract amendment is therefore desirable here to provide certainty for both parties. In NEC 4, new provisions have been included which provide for a treated acceptance or deemed acceptance of the contractor's program by the project manager if he or she fails to respond to such a program. However, again, this does not cover what happens if the program is actually rejected. The termination provisions also need to be carefully considered and amended where necessary. The arrangement and presentation of the termination provisions in the NEC contract is helpful, with a defined list of termination reasons, which are then presented by way of a procedure and amount due for each termination reason, depending on whether it's the employer or the contractor terminating. Although there are 21 reasons for termination in the standard form, the reasons are actually fewer in scope than most practitioners would be used to or would expect in a contract. So, for example, there is no termination at will by the employer. It is questionable whether a termination at will clause would actually be compatible with the mutual trust and cooperation clause in NEC, but this needs to be considered by parties, particularly employers. There is also no provision for termination should the contractor fail to proceed regularly and diligently with the work. Parties should be encouraged to consider at the outset when the contract may end and, if not covered in the standard drafting, document this accordingly. In NEC 3, there are no provisions for collateral warranties, nor is there a readily drafted secondary option clause to easily add in this requirement. So, if the employer requires collateral warranties for a funder or tenant, then an additional Z clause will need to be drafted to include this provision and a suitable form. NEC 4 has introduced a secondary option clause which provides for collateral warranties to be secured. However, it remains to be seen if this will be sufficient to replace the need for a Z clause. Ultimately, academics and some parts of the industry would like to see greater reliance on third-party rights laws rather than collateral warranties, particularly given the Scottish Parliament passing the Contract Rights and Third Party Scotland Bill last week, which seeks to improve the clarity and certainty of third-party rights in Scotland. In reality, though, collateral warranties are likely to remain a feature of construction contracts for a long time still to come. On a general point, the NEC contract provisions address the same or similar issues in different places in the contract without cross-referencing in the related provisions. This is, however, a useful and fairly comprehensive index at the back of the standard form contract, and it's important to use this when consulting the terms of the contract for a particular issue.
Now, BIM, which is Building Information Management, often goes hand in hand with collaborative projects Yet BIM, surprisingly, is not directly referred to or incorporated into NEC 3. NEC guidance suggests that this is done by way of including a BIM protocol, such as the CIC protocol, that's the Construction Industry Council protocol, either just by incorporating it into the works information, which is the documentary information, technical information that describes the works, within the scope, or using a Z clause that incorporates that protocol. But NEC 4 has attempted to remedy this omission by including a new secondary option which specifically supports the use of BIM. Now, this new NEC 4 clause requires the contractor to provide an information execution plan which deals with issues such as the information model, information ownership, and the liability of the parties, which is interesting. We will discuss this, however, in more detail in our next webinar. Now, none of the amendments we've discussed offend against the spirit or objectives of the NEC contract, and they are intended to bring clarity where it's lacking. There are a number of other amendments of detail that we would typically recommend, but which we do not have time to mention presently. Obviously, each project will have its own peculiarities, and consideration needs to be given at the outset as to what amendments are required. So, to end on a positive note, while the NEC 3 contract has its detractors, our experience is that when both parties willingly commit to the additional project management resources that are necessary to operate the contract fully, there are significant benefits for managing and mitigating risks and in resolving claims as they arise in a more collaborative fashion. As stated, it's too early to say whether the NEC 4 changes have adequately addressed the concerns that the industry has had with NEC 3. However, we will have some initial observations to make on this in our next webinar. So, we've now come to the end of the presentation, which we hope has been useful and interesting as an introduction to our webinar series of 3. And we still have a couple of minutes to answer any questions, so if you haven't already done so, please type your questions into the chat box now. And while you're doing that, I will take the opportunity to remind you of the details of the next 2 webinars in the series. On Tuesday, 31st of October, we will be considering the key changes in NEC 4 in detail, and then on Tuesday, 28th November, we will give an NEC case law update and best practice talk. Both webinars will start at 1 p.m, so if you haven't already signed up to those, then please do so by visiting the news and events section of our website. Also next week, we have our autumn series of breakfast seminars in our Edinburgh office on Tuesday, 3rd of October, and in our Glasgow office on Thursday, 5th of October. So if you haven't signed up for those, please do so, because the topics we will be looking at will include design obligations, insurance, NEC 4, and recent case law in construction and engineering projects. Doors open for both events from 8 a.m, with the seminars commencing at 8:30 a.m. So I'd encourage you all to come along, because these are useful legal and commercial updates, but they are also excellent networking opportunities. Finally, this webinar has been recorded and will be available on our Vimeo site shortly. So if you have any colleagues who haven't been able to join us today, or if you think this webinar will be useful for anyone, then please do let them know that, and we will circulate details of the recording to all webinar participants afterwards. Okay, so just before we finish up, we have one question which goes back to the requirement to act in the spirit of mutual trust and cooperation. And the question is what effect that has in the contract. This is something that we'll probably cover in our 3rd webinar, but generally speaking, that principle, which is stated at the outset of all NEC contracts, is simply a principle, and it's not been taken by the courts to be enforceable. It has been argued in a couple of cases now that the obligation to act in a spirit of mutual trust and cooperation equates to a duty to act in good faith, and that this might impose a duty of good faith, for example, when terminating a contract. But the courts have so far not accepted that argument, and I think it's probably widely acknowledged that the statement, as it is at the moment, doesn't go far enough to impose an enforceable obligation. Well, I think that's probably all we have time for today, so thank you very much indeed for joining us. We do hope you've enjoyed this webinar and found it a useful introduction, and it'd be great to see you next week if you can attend one of our breakfast seminars. Otherwise, we look forward to welcoming you to our next webinar at the end of October, when we'll look in more detail at the changes being introduced in NEC 4. So thank you very much.
Thank you.